हेलो एवरीवन, वेलकम बैक टू द लीगल सेंट्स। इन दिस पर्टिकुलर वीडियो हम लोग बात करेंगे दो सबसे बड़े चैलेंजेस के बारे में कि एक सही तरीके का केस लॉ हम कैसे ढूंढ सकते हैं और वेल वर्स्ड लीगल रिसर्च कैसे कर सकते हैं, क्योंकि इन दो चीज़ों की ज़रूरत सबसे ज़्यादा एक लॉयर के लाइफ में पड़ती है। चाहे उसे कोई ड्राफ्टिंग करनी हो या कोई प्लीड करना हो या उसे आर्ग्यूमेंट्स तक करने हो। आर्ग्यूमेंट करने के लिए जब तक आपको सही स्ट्रक्चर नहीं पता होगा किसी केस का कि फैक्ट्स क्या हैं, उसके हिसाब के रेलेवेंट जजमेंट्स क्या हैं, तो इन सब चीज़ों का पता लगाने के लिए हम कुछ रिसर्च करते हैं। उस रिसर्च को करने का एक ऑर्गेनाइज्ड तरीका क्या होता है, इस वीडियो में हम इस चीज़ के बारे में बात करेंगे। ये वीडियो उन सारे वकीलों के लिए है जो अभी नए नए ऑफिसेज में ज्वाइन किए हैं या उनको 2-3 साल हो चुका है, उन सारे वकीलों के लिए जिसने अभी इंडिपेंडेंट प्रैक्टिस ज्वाइन की है, उन सारे वकीलों के लिए जो वकील बनना चाह रहे हैं। तो ये वीडियो में सबसे ज़्यादा इम्पॉर्टेंट ये है कि एक वेल वर्स्ड केस लॉ रिसर्च हम कैसे कर सकते हैं या कोई लीगल रिसर्च हम किस तरीके से कर सकते हैं ऑर्गेनाइज्ड वे में। अच्छा, हम वकीलों के पास टाइम बहुत लिमिटेड होता है। अगर उस टाइम में हम ऐसा करें कि कोई लीगल रिसर्च हमें मिली है और उसको हम करते जा रहे हैं, बट हमें एक चीज़ नहीं पता कि इसको करना कैसे है, एक अप्रोप्रिएट वे क्या है इसको करने का, कौन कौन से वर्ड्स हैं जो फाइंड करने हैं, कौन कौन से ऐसे सेक्शंस हैं जिसके ऊपर हमें ज़्यादा ध्यान देना है, कौन कौन से ऐसे टर्म्स हैं जिसके ऊपर हमें ज़्यादा ध्यान देना है, क्योंकि वही सारी चीज़ें हमारे केस फाइल में बन के तैयार होती हैं और उस केस फाइल के ऊपर ही हम आर्ग्यूमेंट करते हैं। तो हमें एकदम ये चीज़ पता होनी चाहिए कि भाई एक सही तरीके का केस लॉ हम कहाँ पे फाइंड करें, कौन कौन से ऐसे इंग्रेडिएंट्स होते हैं जो हमें केस लॉ फाइंड करने में हेल्प करते हैं और कौन सी ऐसी वेबसाइट होती हैं जहाँ पे केस लॉ फाइंड करना बहुत आसान होता है। इस तरह की बहुत सी वीडियो हम लेके आने वाले हैं, हर जगह पे हम लोग जाएंगे, लेकिन रिस्पॉन्स बहुत अच्छा होना चाहिए, क्योंकि रिस्पॉन्स अच्छा नहीं होता है तो मोटिवेशन नहीं मिलती, और मोटिवेशन नहीं मिलती तो हम लोग करें क्यों। तो अगर आप लोग को लिटिगेशन फील्ड में बहुत ही ज़्यादा इम्पेक्केबल काम करने हैं, अगर आपको अपनी केस फाइल्स ऐसी होनी चाहिए कि जज देख रहा है तो फिर हाँ आपको हर एक चीज़ पता है कि इसकी आर्ग्यूमेंट्स किस पॉइंट्स पे करने हैं। दलीलें कई तरीके की होती हैं, लेकिन एक अच्छा लॉयर बता सकता है कि किस पॉइंट पे आर्ग्यूमेंट करना है। अगर ये चीज़ आपको इस स्टेज पे मालूम चलती है तो आप सोचो आपकी तो वकालत है ना। तो देरी नहीं करते हैं, लेट्स गो टू इट।
Same law cannot apply to different facts. When you even read a judgment or cite a judgment in the court, it all depends on the fact scenario, factual scenario. So your factual scenario has to be similar to the one which you are citing. Now, the relief may remain the same. I'll just give you an instance. There is a suit for partition filed by somebody saying that X has died interstate and you partition the estate of that X. That's a simple suit and Hindu Succession Act will apply to that, partition. The relief is partition of the properties. Now in a different set of facts, the same person files a suit for partition but says that one of the defendant also claims there is a will. There is a will involved, that the person has left a will. Now the factual scenario has changed. Therefore, Indian Succession Act will also come into picture. Whether the will has been validly proved or not, whether it is a genuine will, whether it is the last testament of the testator, etc. So the relief is the same, partition of the properties. But the applicability of law changes because the facts are different. That is why I say that the relief may remain the same, but look for the law which applies to your facts. It's very important. Now coming to the legal research. Now everybody, when I give my juniors files to read and tell them, yeah, इसमें देखो क्या issue है, इसको ढूंढ के लाओ. So what they miss is those first and two most of the times, and even if they do know for 1 and 2 and they come to the third, they do not know how to approach a petition. Suppose there is a petition for probate. Very simple issue. What is the relief grant of probate of a will? Now will is determined by which law? Succession, Indian Succession Act and Indian Evidence Act. If you do not know these two acts, you will never be able to do any research. So you should have read these acts. That's why I was emphasizing, read the acts which are more regularly used.
Pertaining to that particular.
Most commonly filed cases, you should always know the statutes. That is why I was insisting. So once you know it's a case of probate of a will, you will know what statutes apply. So Indian Succession Act, Indian Evidence Act. Indian Succession Act, what you will have to look for is whether the petition has been drafted correctly, because again it's a special statute. So therefore you have to strictly draft your petition in terms of section 276. It can't be drafted in any other way. It can't be drafted like a suit. It can't be drafted like any other petition. For the purpose of jurisdiction, you should know section 264. Remember, in case of probate, there is a concurrent jurisdiction. You can file it before district judge. You can also file it before High Court. So you could have either filed it before the district judge under section 264, or you could file it to a High Court directly under section 300. You can choose that in fact. But the petition will be strictly always drafted in terms of section 276. That is why you must know it. Now coming to proof of will, which will be the legal issue which will be involved. These sections relevant are 63. It talks about how a will is to be executed. Unprivileged will. We are not talking about privileged wills here. We are talking about general wills, the ones which are commonly used. Indian Evidence Act 68. This is very important. It says that if a document is required to be attested, then it has to be proved through the evidence of the attesting witness. It can't be proved without that. If any document is required to be attested, like a will, it is required to be attested by at least 2 attesting witnesses. They could be more than 2, but they can't be less than 2 in terms of 63. So 68 is an important section. It gives exemption to those documents which are registered. So if a document is required to be proved by an attesting witness, if that document is registered, it need not be proved by those attesting witnesses. In fact, you can exempt calling those attesting witnesses. But not in case of a will. Can I know why? Why is this exception for the will? That will, for the purpose of will, you will have to call a attesting witness. Why? Anyone?
So the subject matter of will itself involves
to prove him that he was sane, he was in his senses while making a will.
Close, but not correct. And even why do we need to call an attesting witness to prove a will?
Free will.
Because will is a document of a dead man. The person is gone. So it's logical. See, most of the law which we have is actually based on logic.
That person won't come to
other documents, if they are registered, the executor is coming and proving them. So he need not call the attesting witnesses also on top. But in case of a will, the man is dead.
That registration itself is a kind of an evidence, and that's evidence.
Registration helps,
but
but it doesn't prove a document. Therefore, the only people alive are the attesting witnesses. So therefore, in case of a will, Section 68 says you must call the attesting witness, at least one, if he is alive. We are not obviously discussing the other sections which talk about in case of attesting witnesses are not available. I have written an entire article that can be found on net. You can read on that. That in case the attesting witnesses are not available, how to prove a will. Very interesting topic. Normally everybody tries to prove a will through attesting witnesses. That's the easiest way. But if they are not available, or they disremember seeing the will, or they say that sorry, it was not executed, do we have a choice? So that article talks about those choices. Now let's see how do we research on the issue of proving of a will. Now I'm just going to Manupatra to show as to how we get those judgments. I hope the session is still logged in. So I will tell you the simplest method. So from the slide only I am taking the keywords. We were here, and if we see on the right hand side, what I have stated is always note the keywords from those sections if you want to do research. The keywords are derived from those very sections. They are not magical. So the words which the statute uses, those are the keywords. For example, on the right I have used very simple keywords. Section 63, Indian Succession Act, attested, each of whom presents testator. These are taken out from section 63 only. So there is no rocket science. Section 63 talks about these important words. So I have taken them out and put them. That's why it says keywords. So now we just go and let's see what the results are from these keywords. Let's say section 63, Indian Succession Act, attested, each of whom presents testator. So these are the words picked up from section 63 which talks about execution of the will. Remember to always choose relevance. So if you go on the others, the research will be incorrect as far as the keywords are concerned. So choose relevance, and I have clicked on Supreme Court so that we see only Supreme Court results and just go. Now let's see what the results are, whether we are accurate or not. Let's see the first judgment. See, it so has nicely picked up all the keywords from exactly that provision. And this judgment exactly talks about how to prove a will in terms of section 63C. It also talks about, in addition, section 68, because I told you it's relevant. In case of will, you must call an attesting witness. And 71 and others are actually sections where the evidence of the attesting witness is disregarded. So it's not rocket science to do good legal research on small issues like these and make your boss happy. But to reach here, we do not know the correct way and we get lost in between. So this entire exercise which I am doing is an attempt to help you to reach this stage where you can go your, and give your relevant judgments to your office, and for your own matters also you can research well. So it has cited all the good old law, consultation and submissions of parties, and it talks about the crucial issue involved in the present case is with respect to the validity and proving the concerned will. A will has to be executed in the manner required by section 63 of the Succession Act. 68 talks about at least one attesting witness. Permissive and enabling section. So the results which you will find, if you will know your statute, and the sections will be very accurate. You don't have to waste your energy in looking at other forms of research. If you know your statute, the relevant sections and the keywords, this is the result which comes. So this is exactly on how this entire judgment talks about how to prove a will. Remember, without knowing your basic statutes or basic elementary law, you will never be able to do this. You should know your statute, the section involved, etc. Let's go to the second judgment. See, again, just keywords I put talks about execution of the will and how it is proved. It will also cite all these judgments. Also click on these judgments and you will go to that particular judgment and see what that talks about. This is again on the issue of will. Also one important, one very easy way of researching is you should know your judgment, and if you think one judgment is very relevant to your facts, you can then actually go and put that judgment here, the name of the judgment or the citation of Manupatra, and then go to decision date newest. Then every judgment which cites that judgment will also come.
So there's one more of this. So if you click on the green button, you
Yeah.
actually see the amount of
Sure.
judgment.
So that's what my friend is there for. Don't take his excitement away. He will tell us. You're right that these are all the button for the conveniences to see whether these judgments have been cited in some other platform also. Now let's go to the second example. Now the second example I've taken is of a simple case of 498-406. This is a very regular feature which we see every day. 498A, 406, dowry demand and all of that. 406 talks about misappropriation. So I have just given a short fact scenario that a charge sheet is filed 3 years after the date of offence or the last occurrence. Suppose a woman alleges dowry harassment and misappropriation, though in some cases 406 has been said to be a continuing offence. So therefore the limitation won't strictly apply, but I am just giving you a scenario. The woman says that they had tortured me and from X date I started living separately. At least from that X date 498 stops. So she says there is no contact, they are not harassing me for, and they are not making any demand of dowry, etc. etc. And also there is an issue that the ingredients of the offence or the allegations which are made in the complaint are not met. They do not meet the ingredients which are given under those relevant sections like 498A. Or there are two headings which it talks about. One is demand of dowry, etc. And the other one is that the torture is to that extent that it drives the woman to commit suicide. Those are the ingredients. Now, your client has asked you to file a quashing, or if you are given a file which is a quashing petition. Now, how to approach this research? This is a 498A, 406 ingredients, punishment. We have to read these sections. Note down the keywords from these sections because you are challenging the order of summoning on the basis of, and there is a ground that the ingredients are not met. And then there is also an issue of cognizance taken beyond limitation because the charge sheet was filed beyond 3 years. So the relevant sections in CRPC will be your 468, etc., 469, 473. So now I have not done anything extraordinary. I have just taken the keywords from these very sections 498A and these are my keywords. And let's see what the results come when we put these keywords to our research there. And whether we get the correct results or not. Now our keywords are washing, 498A, Indian Penal Code, so that's the statute involved, and the keywords from the sections cruelty, harassment, unlawful, demand. These are all words picked up from 498A. I haven't created them. These are very simple words mentioned in that section. And then since we were also talking about ingredients, so I also put the word ingredient. Now we go to relevance. Obviously, we stay at relevance and we stick to Supreme Court. We are not even coming to other high courts. Let's see the results. And let's see if we are even close. See, we have come directly to the relevant judgment because we chose the right keywords. And it is a judgment on quashing of these very sections. And this is a judgment of the Honorable Supreme Court. We normally find it very difficult to get the exact judgments. But if we know our law, the statute and the keywords, it is not difficult. So if we go down and we see that in this matter, because I think I have read this judgment too. Maybe, but I'm just saying that these are the judgments, how they come fast. And in the end, if we see that the only allegation which brings the case within the purview of section 406 is the appellant had taken all gifts, etc. Technically, it is allegation for retract definition of breach of trust within the meaning of 405, entrustment of some property, etc. He is only said to have given back to the complainant's parents the entire plot jewelry. No demand was made by the respondent, and in the end, the appeals are allowed. We therefore are of the opinion that prima facie cause has been made out, whereas 498A in this case was not made out because we can research specifically on 498A. Even if you see the results, those will get you much closer to the judgments which you are looking for in a case. Washing of proceedings 405, 406, 498, and there will be so many judgments cited in these judgments that just put those, and one judgment will actually help you in your entire research, because you can pick out those judgments from this one judgment. So if we go down, we will see. In this case, normally the judgments are not cited, but let's see what the result was. See, conscious of the fact that 498 are added to the court with a view to punish the husband or so and so. And in this case also, the proceedings were quashed. Neither 498A, as per the Supreme Court, was made out, nor 406.
So sometimes what happens is that, see, in this case the ratio must be something that we were looking for. But in this particular judgment only, we will find that there was some reference to a judgment wherein the factual matrix of our case and that case might be similar.
See,
so
what you need to do here is, I'll tell you, you will, as I said, you read slowly, you will need to note down exactly the allegation in your case, the complaint, right? Of course, they have to be matching to the allegations in this. You can't say that in your case there were clear allegations of dowry demand, there were clear allegations of breach of trust, but you still can get it quashed. Because in this case there were none. And that is why the Supreme Court has quashed those proceedings. So obviously, that is why I say read the file slowly, see if there are allegations meeting the statute. And if they are not, then look for these evidence. Obviously, if there are clear allegations, then you will have to go through the rigors of trial. And in trial, you will have to prove your defense. You can't seek a quashing at an initial stage. Now just a few more examples. Let's go back to the slide which I had made. Now there was an issue of limitation. Since the cognizance was taken beyond the period of limitation in my opinion. Now let's see. Again, cognizance limitation bar section 468, very simple keywords. No rocket science. So all these platforms like Manupatra, they do magic nowadays. Earlier we would sit on those commentary books, see if there are some judgments there's a question. Then you start reading those books, the judgment, then you see the factual situation, whether it matches to your. Nowadays it has become much easier. Now let's see if we put these keywords, what are the results? So simple keywords, relevance, again we stick to relevance always, and search. Let's see the judgments and whether we have reached close to what we were looking for. And in this case also the Supreme Court went on to quash the proceedings, saying that the cognizance was taken beyond the period of limitation. Also remember, now the law has developed that cognizance is not application of mind by the judge. It is actually calculated from the date when the charge sheet or the complaint is placed before the court. Because it is now believed that courts remain sometimes busy and they don't have time to look into every file and take cognizance. So therefore the period of limitation starts to run from the date the charge sheet is placed, and not from the date when the words that I take cognizance and I summon the accused. Those are not relevant anymore. But in this case the court notes that even then the proceedings are barred by the law of limitation long after a period of 3 years. Due to order failing the code of siege cannot be sustained as the appeal allowed is set aside. And criminal proceedings in PS case numbers also are quashed purely on the ground of limitation. Yes.
Can you please tell me, like, sometimes it happens we find a relevant judgment, facts are completely irrelevant to our case, but the opposite party, the opposite counsel has other judgment which surpasses that judgment. So how can we be very sure that our judgment is most relevant?
See, you have to get closest to your facts of the case. That is the only way you can convince the judge. See, on our facts, this judgment will apply, and not the judgment which is being relied upon by the opposite party.
But if,
see, all the judgments are as good as your facts are. Remember. I mean, in this case only, let's take an example. The Supreme Court talks about the magistrate wrongly noting the date when the proceedings were stayed by the High Court. So what the argument was, that since the proceedings were stayed by the High Court for suppose 8 years, so those 8 years should be excluded. But in your case, you have filed a quashing in which the proceedings were only stayed for 2 years. So this won't apply in that case. So you have to find something which is similar to your matter.
but sometimes it happens here, the facts are relevant, but the observations of the justice are different. So on that basis, the judgment are different.
Right.
So in that case, though, there are n number of judgments, and we can't read every judgment
See, the clarity will come with time. When you keep reading files and you keep researching the law, the clarity will come automatically. At some stages of life in this career, you will feel यार ये तो समझ ही नहीं आ रहा. Even that judgment has a similar ratio, but it decides the law. You know, the law is against me. But in some cases, you will find that the law favors you. Probably you are misapplying your facts to the ratio of a judge. If you get closer to the facts of your case, and that is why I emphasize the reading your brief again and again, then you will be able to exactly know which law will apply to those cases. Trust me, in most of the cases, people say that there are judgments on both the sides. In my personal, I respectfully differ. Judgments are not on both the sides. If you compare very closely the facts, you will find the facts were different in both the cases. And that is why the judges decided one case in a different manner and the other one in a different manner. Everything is applied to the facts. See, judgments are of no use if the facts are very dissimilar. They have to be similar to facts.
He always mentions that you distinguish.
Yes, the word is distinguish. So when we say in court the judgment is distinguishable, that is that the judgment we can distinguish it on the facts. The facts in that case were different. And in our case the facts are these, and therefore this judgment applies. So read the facts and again, and even when you are reading a judgment which is given by you to you by the opposite counsel or the opposite side, read the facts first. You will always find things which are not similar to your facts. And then tell the judge, see, please come to para number so and so, read the facts here. They are not similar to your facts. What we have here is a set of different facts. So therefore we are citing a particular judgment. We always do this mistake. You read a ratio, नहीं यार ये तो हमारे खिलाफ है जजमेंट. वो जजमेंट खिलाफ नहीं होती है, वो facts different होते हैं. So don't get disheartened. See the facts of that case, see the facts of your case. You will always know the dissimilarities and then be honest to your brief. If that judgment applies to your case and your judgment doesn't, then that is the end of it.
Tendency of just coming straight away to the ratio, that has to be changed.
That has to be changed. Every time you read facts of every judgment, people read a judgment fast, they come to the ratio and they say, yaar, isme to ye hua hai. Ab this is what applies to us or not applies to us. Facts will change the judgment. In fact, sometimes when the court is not inclined to grant you relief, then this becomes even more important. Sometimes you will feel the court is not in your favor and the court is not inclined to grant you relief. And you cite a judgment. The judge is not reading the ratio of that judgment, remember that. The judge is trying to read the facts कि मैं कैसे बताऊं वकील साहब को कि भाई तुम्हारे केस में facts लगे हैं, इस केस में facts लगे हैं, and therefore this is distinguishable. And therefore it doesn't apply to your case. So always read the facts of the judgment.
So if you like this video, of course you liked it, I know that. अगर आपको ये वीडियो बहुत ही ज़्यादा इफ़ेक्टिव लगी है तो इसके लिए आपको क्या करना है ये ज़्यादा बताने की ज़रूरत नहीं है, फिर भी बता देता हूँ कि सब्सक्राइब ज़रूर करो, क्योंकि सब्सक्राइब हमारे लिए मोटिवेशन है और इस तरह के कनेक्शंस और इस तरह के नेटवर्क्स हमारे पास बहुत ज़्यादा हैं. और अगर हमें एक अच्छे प्रोग्रेस, एक अच्छी ग्रोथ इस चैनल पे मिलेगी तो हम इस तरह के कनेक्शंस आपके सामने बेहतर तरीके से लेके आ सकते हैं और लोग को इंटरेस्ट भी आएगा. तो मैक्सिमम शेयर करो और कोशिश करो बिना नोटिफिकेशन बेल ऑन किए मत जाना. बाय.